Turning on the radio, right there was your voice. I knew was a child for certain when I made the music choice. That man on DBS radio, my father, I am proud. While I summon you now, calling your name out loud. Make it to the mic, make it to the mic. Make it to the mic, make it to the mic. Make it to the mic, make it to the mic. Make it to the mic, make it to the mic. Make it to the mic, make it to the mic. Make it to the mic, make it to the mic. Dominica, things you did for culture, you know I need your eye. When hurricanes upon us, you brought your natural vibes. Live in your house to broadcast what's going on outside. Why we summon you, might you get to the mic. You always stood tall, nobody knew when your back was against the wall.
Be safe and be prepared. Be a smart shopper this hurricane season. Shop at S-Mart and get the essential hurricane supplies in one stop. A smart shopper will ensure his hurricane supplies includes Crick's Vital Supplies, Spotless Bleach for purifying water and treating of mosquitoes, Oasis bottled water, lanterns, flashlights, and long-lasting Duracell batteries to power your equipment and radio. A variety of canned and preserved foods and grocery items, personal and healthcare items. The hurricane season is worry enough. Worry less. Shop smart at S-Mart and ensure that you have all the supplies to weather the storm before, during, and after.
For all your shopping needs at the best prices in Dominica, shop at S-Mart. Shop smart at S-Mart.
Shop smart at S-Mart.
Can you get me some Lotto?
All my favorite
Shop
snacks.
smart at S-Mart.
I got a top-up, Flow, and digital.
Shop smart at S-Mart.
Sunday to Sunday.
Open on holidays.
Shop smart at S-Mart.
So much fresh fruit and produce.
Good quality service. Unlimited parking. All the best products at S-Mart. You get the best prices.
Shop smart at S-Mart.
Turning on the radio.
Good evening, Dominica. Welcome to another Legally Speaking right here on DBS Radio. We're happy to be back after a lull last week. We know what was happening last week with Hurricane Beryl, and so we had to give the program a pause so that we could pay attention to what was happening to our neighbors, and we really want to empathize with them, particularly remembering our own situation a few years ago with Hurricane Maria. And so we're happy to be back on the radio, the Dominica Bar Association, really educating the Dominican public on your rights and responsibilities. We always say that so that you know exactly why we are here and why the Dominica Bar Association is doing this. I was told that probably in the next, by the next few programs, I myself might qualify to be a lawyer, but I am not an attorney at law, but I'm really happy to be here facilitating the program. And so tonight, we really want to go right into the discussion. If you're tuning in via Facebook, we're asking you to share the live. If you're listening on air, thank you so much for joining us, and we really encourage you to get involved in the program tonight, ask a question, make a comment, because this program really is for you. And so without further ado, I'm going to introduce my co-host tonight. And I have another co-host tonight by the name of Gina Abraham Thomas. Good evening, Gina. Welcome to
evening.
Legally Speaking.
Good evening, and good evening to our listeners. I look forward to this program.
Yes, I'm sure they look forward to your engagement here tonight with them. And so I did not introduce the topic, but tonight we're going to be discussing power of attorney. And I'm sure this, I don't want to say it's complicated, but I'm sure probably, there's a lot to unpack here tonight so persons can really understand what that legal document is about. And so, in order to have the discussion going tonight, we have 3 attorneys at law with us. I must say it's only ladies here tonight. And so I'm going to allow them to introduce themselves. I'm going to Studio 2. Joel, I'll start with you because you've been here before. So just briefly introduce yourself, and then the other ladies can go ahead. Maybe Miss Seja afterwards, and then our final guest.
Okay, so my name is Joel Harris. I am a partner at the firm of Harris and DTA Chambers, and I'm also the vice president of the Bar Association. As you said, it's a pretty long program tonight, so I'm going to just leave my introduction right there.
Yes. Well, Miss Seja, you can tell us a little bit more about you. It's the first time on Legally Speaking.
All right, good night to everyone listening. My name is Indira Seja. I've been a practicing attorney at law for the last 15 years. I'm also heavily invested in education, so I'm a lecturer at the Dominica State College in the Paralegal Studies Department, and I look forward to our discussion this evening.
Wonderful.
And good evening to our listeners and viewers. My name is Fenile Felix Frederick. I'm a practicing attorney for the last 12 years. I am also a tutor part-time at UE, right here in Dominica, and it's just a privilege to be here tonight.
It's a privilege to have all three of you and my co-host here tonight. And along with our listening public, I'm really looking forward to learning a lot myself, as we delve into the conversation. So as I said, introducing the topic tonight, we're going to talk about power of attorney. Usually we don't have enough time, so we're going to get right into the program, and we're going to lay a foundation and explain, or when you say power of attorney, what really is that? What do you mean?
Okay, I think that's my cue.
That's
right, so I'll try to keep it simple. A power of attorney is a legal document in which one person, who we normally refer to as the principal or the donor or the grantor, appoints another person who we refer to as the donee, the attorney or the agent. And in that document, the person gives the attorney the power, or authorizes the attorney to act on their behalf, basically to take certain decisions or to undertake certain tasks on their behalf.
Mm-hmm.
So that is the simple definition of what the power of attorney is. Why would a person want to do that? Give somebody the authority or the power to act on their behalf. I mean, there are usually many reasons why, but the most frequent or the most general reason is because the principal is unable to transact or take care of their personal affairs themselves, whether it is due to illness, injury, or sometimes people travel,
yes,
or they live abroad.
Right.
Even if you don't travel, but you live abroad, but you have business and you have financial affairs in Dominica and you live somewhere else. So this would be some of the main reasons why someone would want to grant somebody authority to deal with matters on their behalf. But it may also be because you choose not to do that particular thing and you want somebody else to deal with it for you. Generally speaking, we're looking at matters such as financial, property matters, and anything to do with business transactions, and so on.
Yeah, I must say that is something that is very particular, right? Because to give somebody the authority to do something on your behalf, especially something legal, financial, you would have to have that level of trust. You would have to actually know what it is that you're doing, the kind of power that you're giving to another person.
Yes, that's very important, that you are very selective in the person that you would allow or you would give that power to.
And that goes into not only the person, but also what you're giving the person the power to do. So probably somebody else can talk to us about the types of powers of attorney. Like, to what extent can you have someone act on your behalf?
Well, there are two main powers of attorney, and when I say that, I'm referring to in Dominica.
In Dominica.
And the general powers of attorney or specific or special powers of attorney. I shouldn't say specific, because all powers of attorney are specific. Special or limited powers of attorney. So the general power of attorney would allow the person to do a lot of different things. So it will allow the person to do financial stuff, manage a person's property, and whatever sort of legal stuff the person can do, the general power of attorney would usually cover those things. But everything would have to be itemized in the power of attorney. So it's not, we often see, like, people come to me and say, I have a power of attorney, it's a general power of attorney, and they show me a document, and it's a paragraph or two, and it says, I appoint so-and-so my attorney to do everything on my behalf that I could do legally, right?
Wow.
No, that's not a general power of attorney according to our law in Dominica. That power of attorney would be almost impossible for anyone to rely on. So if you were to present, so now the purpose of a power of attorney, as she said, is for someone to act on your behalf. When they're acting, they're usually going to be acting with someone or committing someone to something. So they'd be going to the bank and trying to act in your name at the bank, or they'd be going to a tenant or something to try and act as you, as a landlord, to the tenant. So the person who is going to be receiving this power of attorney is going to look at it and say, okay, hang on, did the person give you the authority to do this specific thing that you're trying to do with me?
Right.
So when you have a general power of attorney that just has this thing that says everything on my behalf, it's not something that would generally be honored in Dominica.
So there are still limitations.
You cannot act on that. For a general power of attorney, it has to say everything. It has to say to be able to go to the bank and open an account on my behalf and to close account, blah, 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 to negotiate this on my behalf, to sell my property that is so place. It has to actually state everything that the person is going to be able to do for you, right? Now, a special power of attorney or limited power of attorney is one that is very specific. So I'm traveling, but I want to sell my property at Blackacre to Fernelea, and but I'm going to be traveling and I want this to close while I'm out. I will give Indira a power of attorney for her to close on my behalf. We've already determined the price, and Indira can sign the memorandum of transfer for me. That's very special. It's very specific.
Right.
So those are generally the two types of powers of attorney that we recognize in Dominica.
So if I understand clearly, you have a special, for the special one, it's something specific, maybe one or two items specifically that the power of attorney details that person has the authority to do. The general one, although you can do more, but there are still limitations. Am I correct?
And then limitations with the decision making as well. Yeah. For the general, the decision making is a little bit broader, but it still specifies in what areas.
Right.
But the decision making aspect of it is very broad, so the person can actually make decisions in most cases. But the special or limited, less so.
Yeah, I noted you said in Dominica, and then you said, for example, other countries. Say, for example, the United States. So, can someone have a power of attorney from the United States and utilize it here in Dominica within this jurisdiction?
It depends. Yes.
Yeah.
It's funny.
It
depends. My mic sounds very funny, so I'll just.
It's better.
Okay.
It's better now.
Yeah, go ahead.
Okay. So, if the power of attorney is crafted in compliance with our rules and regulations here, then it would be acceptable. However, you cannot have a power of attorney that is actually crafted in compliance with the laws of the United States and come and register it here. It wouldn't work. So, what we normally advise people to do is that you contact a lawyer in your jurisdiction, which is from Dominica, if you intend the power of attorney to have effect in Dominica, and that power of attorney would be sent to you in America for execution, and it has to be executed in the presence of a notary public, and the notary public will attach the notarial certificate to that document and then send it to Dominica. Once it gets to Dominica, then you have the responsibility to register it. So for any power of attorney that is signed or executed out of the jurisdiction, you have 1 year to register it within the jurisdiction after it has been executed. So basically, it can be done. However, when you're crafting the power of attorney, you have to ensure that it meets the formalities under our Registration and Records Act.
I'm really happy you brought that up. And it's a process, right? So we were talking about this, and so for someone who is listening who has no clue or is really grappling with understanding what this is, can we go through the process of drafting it, registering it, and knowing, so where do we go? Because I've been through the process, and I can tell you my head was all over the place, because if you don't understand what you're doing, it can be a lot. So there might be persons who are interested in doing that. Probably they have relatives abroad, probably they have elderly parents, and they want to do the power of attorney. Is it something that I can draft myself? Does it have to be written in a specific manner, specific paper? All of those things, because I've been through it and I know it's a lot. So can we go through it step by step?
Sure.
Okay, Manny. Okay, so like my colleague said, the first thing you would do, and we always advise, is that you consult an attorney. All right. So although it may be something that somebody can draft on their own, I don't believe the law requires for it to be drafted by an attorney, but it's advisable with anything that has a legal consequence or legal connotation. I always advise people consult the experts,
right.
And the experts are the attorneys. So you come, you contact an attorney. The first question the attorney would want to know is, who are you going to be granting this power to? And some people, I've seen clients come and they just give a name, but the person, they haven't asked the person.
Yes.
Because they just assume that this is their bosom buddy and it's okay. And they will
wait a while. Somebody comes to you and decide they want to power of attorney.
And they'll say, that person, he or she, they don't worry, it's okay. But no, I always advise, can you give me the person's contact, or you contact the person? So it's advisable to ask the person. It's the courteous thing to do, to ask somebody, because it is a responsibility.
Right.
All right. The person has to take actions and certain decisions on your behalf. So they would have to know before. I think it's the best practice. So you would want to know who. And I always advise, like we mentioned, I always ask the person, are you certain this is somebody that you trust? Because the trust factor is very, very important. We cannot really highlight that enough. Okay. Then you want to know what type of power are you going to be giving that person. As Joel said, is it going to be a general power of attorney, or do you want something very specific? So I've seen cases where the person lives overseas, but they're constructing here, doing a building here.
Right.
They've negotiated a loan, but they're not going to be there to deal with disbursements and so on. So they want somebody just specifically to deal with that.
Right.
So that would be the limited or specific power of attorney. So once you know how wide the power is going to be, then you can have an idea. So if it's a general, then usually I will advise them on the various matters that they may grant power to somebody for, because we didn't touch on something. Although, the powers can be very wide and varied, but there are certain matters that you cannot ask somebody to do on your behalf.
You can ask somebody to marry.
You cannot delegate personal tasks. You cannot ask somebody to marry.
You cannot ask somebody
or
to
vote.
Or to vote.
Or to go to your workplace.
For you.
There's some things you can.
There are limitations.
And actually, just not to
no problem.
interject, just before you also, under all law, you can't appoint someone to make healthcare decisions for you.
Okay.
Yeah.
Or draft your will, or change
Or
your
draft
will.
your will.
Or change your will, or those things.
Okay.
Exactly.
Okay, yeah.
So if it's general, I would advise them on the ambits, where how far they can go with the power. If it's specific, then they already know what they want.
Right.
And so then I would go about, I take the instructions, as we say, and then I would, draft something with all the legalese that is required. Usually it's advisable to have the client read a draft of it. So you email it to them, they read it. Most times, some of them, they read it and they tell you, well, they don't even understand what's in it, but they trust. They trust you, right? But I always ensure that I would go through the different provisions. So like Joel said earlier, if you want somebody to take care of your banking, it has to be specific. Which bank? What exactly? Is it to just open accounts, close accounts, deposit money in the accounts, whatever it is? I would draft it according to what the person has instructed me to do. And explain to them exactly, this is what you're doing. This is the power you're giving to the person. Do you understand that power?
Right.
I would also speak to the donee sometimes and tell them, look, this person has asked, to appoint you as their power of attorney. Are you willing to undertake that responsibility? It's a position of trust. Are you willing? Are you available? And the person, so most times they're very skeptical because they always believe that liability is going to attach to them for taking certain actions. And I said the only time a liability will attach to you is if you do something contrary to the powers. that are given to you, but otherwise anything you're doing, you're really stepping into the person's shoes. So when you sign, you're signing as if you were the person granting you the power. So if you sign something and there is a legal conflict, the liability really is the person's,
Right.
you know, unless you did something not in accordance with the law.
Right.
So I'll do that, and then we draft. The document has to be done on deed paper, all right, because it is an act, it is a deed, it has to be registered, so it cannot be printed or done on regular paper.
Right.
So that's one thing I always advise the clients. So it's done on deed paper. Once it's drafted, the client, the donor, usually who is the client, that person. I've seen somewhere both donor and donee sign. It's not a legal requirement for the donee because you're receiving the power.
Right.
But the person granting the power for obvious reasons, legal reasons, has to put their signature on the document. That signature must be witnessed. All right. So I think one witness is sufficient. Sometimes for elderly people, especially elderly who are under medical care, I sometimes get 2 witnesses. Or sometimes I would advise for the witness to be a medical practitioner or the person who is dealing with them medically, just to avoid any kind of conflict in the future. But usually it can be anybody who is of legal age. So a witness, also the principal and the donee, all must be persons of legal age. In Dominica, legal age majority is 18 years. You must have sound mind. So both the parties and the witnesses all have to have sound mind.
Sound mind, yeah.
Yes. So once that is done, everything is signed, you get your witness. Now, as Fanny was saying, if it is executed here locally, the witness then has to complete what is signed before a commission of oath, what is called an oath of execution, to just verify that they were present and witnessed the person signing for their own, they were not forced. Right? If the power of attorney is going to be executed overseas, then we need a notary to be the witness.
Yeah.
And then in that case, they prepare and sign and forward to us here a notarial certificate with the power of attorney. All right. Once all of that is done, that power of attorney has to be registered. The first step in registering the power of attorney is to go to the treasury, and where it has to be stamped. Okay, with the stamp duty. We have to pay stamp duty, right, on the power of attorney. That is $15. All right. So that is paid. It receives the stamp duty. It receives a physical stamp. Once that is done, we then take it to the registry where it is going to be registered. Before it can be registered, it also needs some more stamps. This time, adhesive stamps, right? Because by law, every 9 lines of the power of attorney is $5 stamp. So we go through and you count your lines. If it's 2 words on the lines, it's a line. You count it. So what I find on average, if it's a basic or simple power of attorney, I would think about $30, $35. And then when you have the longer ones, I've seen some $65, $75. All those stamps have to be stuck onto the actual deed paper on the document. Now, at that stage, before you actually hand it over to the clerk to be registered, you do a copy. Because what happens is that when you do the copy with all the stamps and the stamp duty on it, the copy and the original are given to the registry, are submitted in the registry. When the process is completed in terms of the registrar looking at the document, ensuring that everything is okay, it was signed properly, witnessed and everything, then it is recorded in the deeds book with a number and all of that. You get back your original, because as you imagine, you need that document as the donor to be able to take to the various places, the banks and so on, to say, here's my authority on which I'm acting. The copy is what remains with the registry, and then you keep the original. So that in a kind of a nutshell, I think.
Yes.
But Indira touched on a very important point.
Yes.
Not just the signing, but the especially when you're dealing with elderly customers, to have them execute the documents in the presence of a medical practitioner. And the reason for that is that sometimes you have conflicts, and then another family member will say, oh, you force the person to sign it, or when the person signed it, they were not of sound mind. What that does is that it eliminates the possibility of these challenges coming up, because then you have the person executing in front of a medical practitioner who will say, well, yes, when so-and-so signed the document, they were of sound mind, they understood, they were able to give instructions clearly. So at least it limits the amount of challenge that you can have for that particular document. And it also protects you in the sense that nobody can come and say undue influence, that, you force the person to do it. So it's a very important aspect. It is not a necessary step, but if you want to take that extra precaution, it is always recommended.
Okay. In fact, what is often done is before even taking instructions, if it's an elderly person, to get them assessed.
Yes.
First, so that you know that this person is, because I might be seeing you for the very first time, you might seem perfectly fine to me, and you might not be perfectly fine.
That's so
and
true.
I'm not a doctor. There's certain questions lawyers can ask where we can try to determine whether the person has a mental capacity, but you can't always know. And so it's always best, if you're dealing with, as an attorney, if you're dealing with an elderly person, have them assessed before you even take the instructions, so that you know that the person has the capacity to give this power.
Wonderful.
And while Indira was speaking, she spoke about signing. Sometimes people get a power of attorney, they're the attorney, and they don't know how they're supposed to sign. So do I sign as Joel Harris when I'm doing something on your behalf?
Yes. Or do I sign as myself?
Or do I sign as myself?
Yes.
Do I sign
Very
as
important.
a person? What do I? So usually we would advise that they sign Joel Harris as attorney for so-and-so.
Right.
And if you want to be really, really careful, you can even maybe
On the power of
reference
attorney.
the power of attorney's registration number
or the dates.
Yes.
Or something like
One more thing, I thought that's what you were going to touch on, but that's what you said is because people, a lot of the time, they sign as the person. I've seen people try to sign.
But that's forging.
I say that is forgery. You cannot sign as some. I mean,
Yeah,
I think in the US, in some places, they do allow them to do that.
To write the person's name,
You
to write it out, yes.
There's sometimes, when the power of attorney is drafted in such a way that it says to act in my name and to do these things on my behalf. So it may be okay to sign in the person's name, but I prefer so that it's clear.
Right.
I prefer to advise the person to sign your
For that
name
person.
as attorney for and
right.
reference. That's the best way.
Yes.
No confusion. Nobody
It's
gets.
true, yes.
This is not the person's signature later on. It's clear
Right.
what you're doing.
Yeah.
In terms of signing, before we before we go on, the actual power of it. So we're talking about signing once you have received the power of attorney and you have to do a transaction. But just to go back a little bit, in terms of signing, sometimes we have donors who cannot sign. Right, so I've had cases where the donor is an elderly person or somebody who just is unable to write for whatever reason. So they do accept a thumbprint just as with anything else, but then I take the extra precaution and state that the person is unable to. And again, in those cases, we do either get an evaluation done before, or again have and it's not just any medical practitioner. I always ask for the person who is the doctor for that person over a number of years, so they know them, so to just indicate that they're unable to sign, hence the thumbprint, and then I do 2 witnesses sometimes just
to
so
be
nobody
sure
can see this is not the person's thumbprint. Just take that extra precaution.
But Indira, it's not just a precaution. The law requires you to actually, because there is an attestation clause that you must put at the end of that signing block to say that the person was unable to sign by whatever reason, and that before the person signed, if it's somebody who cannot see properly or it's just they have a problem with writing, then you have to also say that I read over the document to them and they fully understood it and they signed in my presence. So there are special requirements where you have situations like that.
And I would absolutely understand why you have to go through all of that. I mean, it seems tedious, but then again, you have to make sure that everybody is protected in that. And so we want to remind those of you who are listening, if you would like to call in to make a contribution or ask a question, the local numbers to call, 1-800-327-448-3281 or 448-3279. If you're calling from outside of Dominica, 1305-432-9744. Very interesting topic, I must say myself. I mean, we spoke about the elderly. We spoke about, persons being away, all the different reasons why we may need to have that document handy. What makes that document null and void, or how long does it last? Does the document itself specify the term period? Yes.
There are several ways power of attorney can terminate. One of them is by effluxion of time, and that is specifically for special or the limited power of attorneys. So, for example, if you grant a power of attorney to somebody for a specific purpose, once they achieve that purpose, the power of attorney becomes null and void. If you give it to them for a specific time, once the time has elapsed, then that power of attorney is null and void. So, for example, if I give you a power of attorney to act for me and I say, you are to act while I'm out of Dominica, the moment I return to Dominica, that power of attorney is null and void. It can also be terminated by revocation. So if I, as the donor, revoke the power that I grant you, then it is terminated. And for revocation, you would have to go through the process of creating a revocation document and having it registered, just like how you had the power of attorney created and registered. And then it can also, from the time the donor becomes mentally incapacitated of unsound mind, then the power of attorney terminates. And the reason for that is that when you grant a power of attorney, you create an agency relationship. So your power comes from the donor. So if the donor cannot give the power, then you cannot have the power. So once the donor becomes of unsound mind, the power of attorney terminates. It becomes null and void. And again, also, if you grant a power of attorney to a donee, and that person is not willing to accept that responsibility, then the power of attorney terminates.
I mean, but
you forgot one last one. If the donor
dies, if the donor dies, the power of attorney actually automatically terminates.
And I just wanted to add one other thing with regard to the revocation.
Oh, sorry.
An important part of the revocation is service of this. Yeah, you have to notify the attorney that you've revoked it. And if the attorney, if the power is allowing the attorney, for example, to do something at the bank, you need to serve it on the bank as well.
When you're talking about the attorney, no, you're not talking about a lawyer. You're talking about, and I think that is can be a confusing word.
Attorney in fact.
Attorney in fact. So that's the person you're granting the power.
Actually, before Indira and I came, we said this thing is so confusing. When we say attorney, people are going to be wondering what are you talking about. So we're going to use the word donor for the person granting the power and the donee for the person receiving it. So let's make it clear.
The educator in me is always wanting to educate. So
That's
even
true.
if we're going to use donee and donor for the people who, because I remember before I became a lawyer, it used to confuse me. Why are they calling these people attorneys? Because I know an attorney is so you have attorney at law, and attorney in fact. Attorney at law obviously is somebody who has completed a course of study and has their license and whatever other legal requirements to practice law. Attorney in fact is a person who by your own act, you have made your representative, right? So that's what attorney in fact. So sometimes we use it with attorney, but it gets confusing. So as Lydia said, we'll stick to donor and donee.
Yeah.
But it really is, because even when you do legal documents, in the documents you refer to the person as the attorney. The attorney shall and the attorney may and those kind of things. So.
Yeah, because even imagine you're reading this document and you see the attorney, and you were thinking it's not the person, it's a lawyer that's supposed to be the lawyer. Yes. And I mean, I would argue my case. Attorney is lawyer,
and an attorney can be an attorney at law can be an attorney in fact. But we shouldn't, if let's say you're the one involved in the particular transaction, probably stay away. But I'm actually an attorney for somebody, but it's something totally, I'm not dealing with the legal matter for that, so I can. So an attorney at law can as well be an attorney in fact, just so people know.
So someone is asking, Rosaline is asking on Facebook, we might have answered that. When the person has passed and the power of attorney doc is done, what happens when the holder continues to hold on to the property?
Once the person dies.
Well, I'm not sure exactly what they're asking.
Why were they holding on to the property?
But whenever the donor of the power dies, what should happen is that if you know of the existence of a power of attorney, especially if that power of attorney references actions or activities that the person can do, the donee can do in terms of banking transactions, what should be done is that a copy of the death certificate, or if you don't have the death certificate, a death card should be served on the bank to put them on notice that this person has died. So from the time the bank receives that document, they are aware that the person has died and the power is null and void. So if anybody else comes to transact, then they would not allow them to. In terms of property, if you are holding any property for anybody, for any donor who has passed away, you must relinquish that property to the estate of the donor, because the property does not belong to you as the donee, because you're just a trustee.
Right.
So you're holding for the beneficiaries of the donor. So at the end of the day, you really have to relinquish all property that you have that belongs to the donor, and normally it is given to the executor of the estate if the person dies with a will and nominates an executor.
Right.
If they die intestate, which is without a will, then that property is supposed to be handed to the administrator of that person's estate upon the production of the grant of letters of administration. So you have to ensure that the person who you're relinquishing or giving the property to actually has the authority to receive it, and the person who would have the authority would be an executor under a will or an administrator under grant of letters of administration.
So a really simple answer to that
Yes,
is
please.
when the person dies, the power of attorney dies. So
It
just like the
dies.
person
It
no longer
dies.
can do nothing,
Exactly.
you can no longer do nothing.
And then to
right?
answer the
And
question, what
if you
should you
do
do?
anything,
Right, exactly. What
then
should
you're
you do
you're
next?
acting unlawfully.
You're acting
Right.
unlawfully.
You're
so-
acting without legal
Right.
authority.
So they cannot hold on to the
So
property.
So you cannot hold on to the
Anybody can
property.
sue
No.
you.
So,
Anybody
exactly. So,
who's
Rosalind, you can-
beneficially
yeah.
interested
Yes.
in the property can sue you.
Exactly.
So that yeah.
Right.
That's
We want to thank those of you who are listening from outside of Dominica, Annette listening from Boston, and Cecilia listening from New Jersey. Welcome, welcome. So the person is responding again. Rosalind, she's saying, great answer. Is this always explained to the one who held the power of attorney? Otherwise, it would be illegal.
Yeah, well, I think
We
we
won't
mentioned
know.
that earlier.
Yes.
I know
It
we
should.
should. It's the
not
prudent thing to
always.
do.
Yes.
To explain to the person, what the what their powers are, and when it dies,
When it dies,
it becomes null and void.
that's it. It's not
And
like,
lots
the
of-
person
lots
dies,
of-
so the land is now mine because I have the power over attorney.
No, it doesn't work that way.
Doesn't work that way.
Doesn't work that way.
It doesn't
At
work
all.
that way.
At all.
It doesn't work that
And
way.
in fact, a lot of times, because with internet and everything, we're so aware of what happens in other countries, and
Right.
sometimes we confuse it.
Mm-hmm.
So sometimes people think that when the person becomes incapacitated mentally, which means that, let's suppose they have Alzheimer's, or
Right.
they have a stroke and they're no longer able to function, or they're in a coma. For example, people think that I have this power of attorney. Now is a really good time. It's very useful now. because
Right.
They cannot do anything. And they trusted me, and I'm not going to do anything bad. So I'm going to continue acting on this power. But no, in Dominica, we
It's
don't
null and
have
void.
the law that would allow you to continue acting.
And that's the thing, though. That's a question that I was gonna say. Let's circle back, because this is a very interesting aspect of this. Because you're thinking at this point, this is when the person truly needs someone to act on their behalf, especially when they gave that power in their sound mind, and now that they probably they have dementia or whatever, they're not able to anymore. Then you expect that you should be able to act on that person's behalf. So what can be done otherwise? Because this person has property, they has whatever. We can't use the power of attorney. What can be done?
Okay, so if the person has lost their mental capacity, at that point, the only thing you can do in Dominica is apply under our Mental Health Act to be the receiver for the person, and that requires you going to court, and having proof that the person is not mentally capable from a doctor and other things, and you make an application to the High Court requesting receivership to do. You should be asking very specific things. Our law does not have regulations, and so it does not have a lot of the checks and balances that probably it should have, and does not specify some of the requirements that should probably be specified. So that procedure can vary depending on the judge that's sitting at the time, and how interested the judge is in those matters, how experienced the judge is in those matters. So in some cases you might get a judge accepting a medical from just a normal medical practitioner saying so-and-so had a stroke and is not mentally capable. Another judge might say, no, I need it from a psychiatrist to establish that it's really the person is of sound mind. So this is some areas of our law that probably should be addressed.
Yes.
If somebody wants to give a power of attorney, and they want, and while they are of sound mind, obviously, and they want it to carry on beyond them losing mental capacity, they cannot do that in Dominica. In other countries, they can. In a lot of the first and second world countries, they have laws which allow for that. They're called either enduring powers of attorney or lasting powers of attorney that can allow you to carry on doing business for the person after they've lost their mental capacity. In Dominica, if you wanted somebody to maybe manage your business or transact certain things for you, you could always do a trust. And that way, if you lost your mental capacity as a beneficiary, the trust could still carry on. But that's expensive, and there are taxes and there are lots of things. So it's not something the average person will do, and it's not always something that is not necessarily what you really want, because a trust is a very complicated thing. So unless it's really like a business that you want to be able to run, you find that doing a trust might be more trouble than it's worth. So in our laws, you really don't have a way of making a person your attorney to survive should you get dementia. And this is something actually, which is one of the reasons why we're having this program tonight, is that we get this request all the time.
Yes, because I'm thinking, how do you take care of this person? Probably at that time you need to, access, if the person has any monies in the bank, access that to take care of the person, if the person is hospitalized, that sort of thing.
Sorry, go ahead.
Yes.
To continue. I was just saying, in terms of, so it's not, it's probably one way of probably combating this problem, especially for like the financial aspects. Maybe one thing that people can do is have joint accounts or have somebody be a joint account holder with you. What that does is that if something happens to you, then the person...
No,
I see. Okay, so I'm going to step out and let the expert deal with this, because the bank may have their own thing. But I'm just saying, let's say it's a husband-wife situation, or some that kind of relationship.
You could do that,
because that is one way. Because if something happens to you, then the other account holder should be able to access the account. The expert will talk a little more about that, or even things like property and so on.
The thing about creating joint accounts is that you have to know the implications of creating a joint account.
Right.
Number one, the first issue that comes up is the issue of trust, because this account gives the person access, unlimited access to the monies in the account, regardless of who actually put the money in.
Right.
So you could put your whole life savings into this account, and you create a joint account with somebody else, the money automatically belongs to that other person.
Right.
So it means now that they have free access to the money, especially if you do not say that in order for you to access the funds, you need my signature.
Right.
So that is one issue that I have with joint accounts. The second issue is the fact that you have the principle of survivorship, which attaches to joint accounts. So it means that whenever an account is held jointly and one person passes or dies, the other person automatically becomes the owner of the account.
Right.
It doesn't go to your estate. So you may want to create a joint account just for example, an elderly person cannot walk properly, cannot go and get their medication. They give you access to the account just to do those things for them. But because of the fact that it is a joint account, when that person passes, the money automatically passes to the other holder under the principle of survivorship. And sometimes that is not what the person really wants. So you have to be very mindful of the implications that attaches to joint accounts before you make that decision. Yes, it may be convenient, but with everything else, there are limitations and challenges.
Exactly,
and I think that when we as attorneys are advising, we have to advise fully. So you let the person know everything that can go wrong, everything that can go right, and let them make the decision
for
as
themselves,
to, and another very important point about choosing the right person to act for you, whether it's under a joint account or a power of attorney, is the aspect of trust.
Yes.
We just cannot
overemphasize
you cannot
that.
overemphasize that aspect of trust, because the kinds of horror stories that we hear as attorneys, I give a power of attorney to so and so, my mother fell ill, they sold all the properties, put the person in a home, and then they escape with all of the money. You cannot find them to pay the medical bills. They overseas enjoying the money. So, these are things that we need to be very, very, very careful about.
Yeah, and this is something when Indira was speaking earlier about when the person comes and the conversation you have. This is very, very important. At the time when the person is giving instructions, and this is for attorneys, but it's also for you. If you go to an attorney, it is important that you describe and explain to the person everything that can happen with regard to every clause. So when I do, whether the person is elderly or not, if I'm doing a power of attorney for someone, after I've done it, I read it over to them and I explain to them every single clause. And I make sure that they understand what that entails, the full extent of it, and if they want any restrictions. So for example, let's say they want the person to be able to use their account, but not beyond $500.
Right.
Then you put that in the power of attorney.
Right,
That's
right.
fine. And when the bank gets that, the bank will limit their use of the account as
Right.
instructed in the power.
Right. So you can be as explicit as possible.
You
Yes.
ought to be. It's
Yes.
very important that you are. And if the person is not being sufficiently explicit, I make sure I explain to them. Okay, if you do it this way, that means the person can close the account. Are you okay with the person closing? No, I don't want them to take all my money. Okay, so then I have to put provided that at no point in time does this power, shall this power mean that the account shall be closed or whatever the case is. So it's really, really, really important to sit down with an attorney and to go through this very, very carefully. Even something like consultation. So sometimes a person wants to give a power of attorney.
Can you hold on a bit because we have a call on the line? Is that okay?
Yes, of course.
Good evening.
Hello, good evening.
Good evening.
That's the program on DBS Radio.
Yes, that's the program on DBS, legally speaking.
Yes, my dear. It is so, I listen to that program there. And it's tremendous. What my father went through with my siblings is that same issues you are discussing there now. And my sister now, so from dementia. 6 of us. We have one sister, my dear Elas. All I consider is my shepherd. Exactly what you are speaking about here. And if all of them, the whole 5 of them, were listening to me, their brother, when daddy falls sick and when they have to get the same psychiatrist and do all those things, daddy died. And right now, my days are 5 down. It was so, I don't know what word to use, but what you say, my sister now, sorry, from dementia. She was one of the signatories on my father's everything. What you're speaking about, she was one of them with my older sister. And she suffered from dementia, no, my ladies, my attorneys. And you just have to go and sit down with one of you all and explain to you what my father went through, my sister now. She was a teacher. From dementia now, and the same thing that he had. My 2 children, one died, my son, may he full rest in peace, taking care of his grandfather before them, one is still studying. And my sister now, from dementia, and one of my sister. What you're speaking about there, exactly what I've done again, my sister. I am the one right now coming, what my sister did to me, and doing everything I can to help my sister. Make sure I give her lunch, make sure I come and sit. When the other one call me, I tell you, anything you want, call me. I am there. And she won by all means. She's the only one to do everything for our sister.
Yeah.
And the 4 of them I was fighting long, 2 of us to want to see her now. I mean, my dear, say thank you, yeah?
Yes, you're so welcome. And like you said, probably you can visit one of our attorneys and most likely they might be able to give you some advice. Probably something that you're not seeing, they'll be able to help you.
Yes, I asked one of the same sister of mine to Mrs. Knight the day where her office is. Some weeks ago to come and speak to her. She said, I'll look for you, I'll check for you. I mean, another person, I'm a farmer and I'm everything, but I would like to go and come and sit down and speak to one of all you.
Yes.
Please.
Thank you so much for calling. Have a good night. Yes. So I guess these are kind of the stories that you hear all the time.
Yeah, all the time. And in situations, he didn't go into detail, which is fine, but in situations where someone with a power of attorney acted wrongly or acted at a time when the person was already mentally unsound, or did anything that caused damage or loss of property, the beneficiaries of the person, if the person has died or if the person is still incapacitated, can take action on their own behalf or on the other person's behalf. So it is something that he didn't go into it, like I said, but if it is something that he could go to a lawyer to see if there's anything that
can be done. Do. Yes, I think he should do that for sure. We want to thank those of you who are here with us online. Zetma listening from Collyho, Fanny King saying good night to all of you, and thank you so much for commending this program tonight. And we're really happy that you can grasp something from what is going on here.
Something occurred to me when the gentleman was talking, maybe a little bit off what he was saying, but something we forgot to touch on is that the donee it doesn't have to be one person. You can have 2 or more people acting jointly. They may act jointly or they may act jointly and even severally, meaning that although they're both granted the power, one of them can act on their own. If you don't put that clause saying jointly and severally, then the law assumes they must sign off on everything jointly. So I advise clients what that means and what the repercussions may be. So I've had cases where a mother might give her son and daughter the power of attorney. So I'll ask them, do you want to be, because one lives overseas, one lives here. Do you want to, if you put jointly, it means that every time you sign off on something, you have to send it overseas for your brother to sign off on it.
Okay.
Then I'll ask the mom, is it a case where you trust your kids to act on their own? She says, so then you put jointly and severally so that they know they can act individually
or together.
Or jointly.
Okay.
But if you don't put that clause in, it means that they must act jointly. So that's something that just triggered in my mind when the call was talking.
Well, I will say what will constantly remain on my mind is the fact that when you become mentally incapacitated, it becomes so difficult and it becomes null and void. I think that, is a sticking point.
And especially, it's unfortunate that we don't have the law because, a law like that, which allows you to do an enduring or lasting power of attorney, allows you to have some control over who will be the one making decisions for you when you lose your mental capacity.
Right.
So if I do a power of attorney and I say Fenilia will be my attorney because I trust Fenilia. I have 2 children, Fenilia and Indira, right?
Trust me more.
And I trust Fenilia more. I like Indira, but I don't really want her watching my account, So and then I lose my mental capacity. Indira, being one of my children, can apply to the court for receivership, and she can end up with it, especially if she doesn't serve Fenilia, and I might be living with Fenilia, and she might go and apply to the court and not serve Fenilia with that application. So Fenilia doesn't even know that she's making the application for receivership. And under our law, as it is, she could actually get it. Without me or Fenilia knowing that the application was made.
I need you to repeat that. Yes. Okay. So can you just repeat that for me? I want to make sure that I get this.
Yes. And this has happened. I'm using Fenilia and Indira, unfortunately. But this has happened. I may be an elderly person.
Yes.
And I may be living with one of my children. And this is a child that I trust, and I give them a power of attorney.
Your favorite child.
Subsequently, my favorite child. Subsequently, I lose my mental capacity. At that point, the power of attorney is no more.
Right.
So Fenilia, who I'm living with, can no longer act for me. So if anybody wants to act for me, as our law currently is, they must apply, like I said earlier, under the Mental Health Act for receivership.
Right.
So they will apply to be receiver for me. And they will get whatever they need to get or determine what their lawyer determines they need to get at this point, because our law is not very specific on that. So usually, depending on the lawyer, you get different things. Depending on the judge, certain things go through. So Indira, who's also my daughter, will apply to the court. And because our law does not have a requirement, specific requirement or regulations which specify that the application must be served on the household where I live, which is actually in a lot of other legislation that deal with receivership or regulations that deal with receivership, she may very well apply to the court and get receivership for me without me, well, I have no mental capacity,
Right.
without Fanilia, who I'm living with, knowing this.
Right. So some
And she can then go with that order to the bank.
right.
She doesn't have to go to me. She doesn't have to go to Fanilia. She doesn't have to serve the order on anybody. Well, usually at some point they will serve it on the patient, right, who doesn't have mental capacity. Anyway, and she can go to the bank with this order.
And she can act on my
She can
behalf.
withdraw on my
She can withdraw from my account.
She can withdraw all of my
Yeah,
money.
so because someone here is asking, Jada is asking, so in that case, it is not necessary to get consent from the other children.
It should be.
It should be,
But it's not.
Yes.
This is what I try to do. I try to, if I am doing it personally for someone,
right.
I will try to make sure that either the others consent to it, or at least they're notified of it, even if they don't live in Dominica, right? But it's not a requirement under our law. So some lawyers might not do it.
And in relation to what Joel said as well,
Yes.
it's dependent on the judge as well. So some judges will inquire as to, okay, how many children does this person have? Do they have knowledge? Who does this
Correct.
parent live with? And this sort of information. So then, you are properly informed.
Right.
But there are others who may just, look at the information which is presented or filed and decide that they're granting receivership.
Yeah, and
so
like
it's very
Joel was saying,
important
it's
to
not
have the
regulated,
information.
so
Yes.
There's no
it's
regulation,
based
so
on,
it's really-
so that
Yes.
can be very ticklish. Vernice is asking, I'm not sure if we've answered that before, but Vernice is asking, in the case where mom dies before dad left property to someone instead of children, the property belonged to both parents. What action can the children take? So that's something else.
That's power of
that's
yes. Not related to
that's
power of
something
attorney.
else.
That is probably a succession
yes,
probate
yes,
or
yes,
something.
that's
Yeah,
related to
and
something else.
You'd have to, we
And
did
that's
some of this
dependent on a
before
number of
We
because
did,
when we
yes.
dealt with land interest,
Yes.
but you'd have to go into some of that.
Yes. But like we tell our listeners, sometimes we don't, but most times we try our best to answer questions that are posted under the live. Joel, I'm putting you under pressure for this one. We want to thank Jim, who's listening from viewing from Antigua. Thank you so much for joining the program. Yes, so we're probably just a quarter through what we need to discuss here tonight, and it's already 9 o'clock. But I'm sure, yes, it is.
But before we go,
we can continue. I think we can take another 5 to 10 minutes and sort of like breeze through the rest of our discussion. I'm gonna leave it up to you to bring up what you think is most pertinent for us to really talk about right now.
Okay, so I'm going to touch on two areas.
Yes.
One would be the fact that people need to know that they need to review their power of attorney.
Mm-hmm.
We sometimes just figure that we give a power of attorney and that's it. No. If you want to change your mind, it's okay. You can change your mind. You can take away or revoke powers that you have granted. You can give powers to somebody else.
Hold that thought. We have a call on the line. Good evening. Hello, good evening.
Hi, good evening.
Good evening.
I have a question.
Yes.
If you have a family and the mother dies and the mother left one of the children with the power of attorney who developed a mental incapability of dealing with the business of the family. The person who developed that mental incapability is married. Can the husband of that person file for receivership over what is belonging to the rest of the wife's siblings based on what the mother and father have left?
I think.
Did he say the mother
The mother died.
with
He said the
leaving
mother
up-
died, leaving the power of attorney. That's what you said?
Yeah, well, the power of attorney dies.
The mother died. The mother dies, but the daughter who has power of attorney and also was how they call it, the person who holds the will.
The executor?
Oh.
the executor. That is the word.
Okay.
The executor developed mental incapacity.
Oh, so it's a will.
Oh, okay.
It's
So
a
it's an
will.
executor.
It's an
Right.
executor.
What happens to the siblings? Because what I'm trying to figure out, what if the husband of the
And as the husband of the
wife
sibling, you know.
files for receivership of everything which falls under the daughter who has
Who is the husband of the
the
baby?
who is the executor?
Mm-hmm.
Can the husband become the executor because the wife does not know anything that's going on around her? That's all. I will wait to hear your comment.
Yes, thank you so much for your question, caller. Have a good evening.
This one is a very loaded one.
Yes.
It's not really on power of attorney, it's really on succession law. And I would advise the caller to seek guidance from an attorney because this one has a lot of issues that we cannot unpack in 5 minutes.
Mm-hmm. Yeah, so caller, hope you got that. You need to see an attorney. But you can't brush over it, not even for 2 minutes. It's heavy.
Well, the husband does have the authority to apply for receivership.
Of his wife.
So he would be able to deal with the property of his wife.
Mm-hmm.
But as it pertains to the property that I'm assuming, because he said executor, so there's a will.
Yes.
As it pertains to the property of the mother, he would not be able to fully administer that estate because there is no chain of executorship.
Exactly.
So really and truly, any of the other beneficiaries can apply for a grant to allow them to be able to deal with the property
Estate.
of the mother.
Right.
But the husband would have the authority to apply for receivership to deal with the property of his wife.
Of his wife, but not of what belongs to the siblings as she being the executor. Right.
Because he's not entitled.
No.
Right.
Since we're discussing power of attorneys, though, too, a person can grant power of attorney to somebody to deal with administration of estates and so on. So you can actually appoint somebody to deal with, apply for the grant of probate or the grant of administration on your behalf. There's actually, we have laws in place for that. So, I mean, on a long stretch, depending on the relationship.
It wouldn't apply in this situation, though, because the mother is dead. The power of attorney would have died if it came from her.
Dies,
and then the wife is mentally incapacitated. So it means that if she gave a power of attorney to apply for the grant, then that would die.
I was actually referring to maybe one of the other beneficiaries, depending on the family dynamics. I'm talking about one of the actual next of kin or beneficiaries who are eligible to apply. But as like I said, that's a long shot, and we cannot unpack that. But it is something. Let's say if you can grant a person. So if you are the beneficiary of somebody's estate, whether it's your deceased mom or sibling or whatever, you can actually grant or appoint somebody else that power under power of attorney to apply for the grant to deal with your estate. You know, so that is something that's
to
possible.
apply on your behalf until you have time to apply yourself. So it's a very limited power of attorney. Very limited.
So it's limited. Okay,
and you can't. And I want to just make this point because it's something that a lot of lawyers do. And a lot of lawyers maybe aren't aware that it shouldn't be done. We, in Dominica, we actually cannot give a power of attorney. Let me say it this way: a person who has probate or letters of administration to a person who's acting as the executor of a deceased person or a person representative of a deceased person cannot give a power of attorney to someone else for them to act.
In that capacity.
Okay.
No, in England, there's a law that allows it, but it limits it to 12 months.
But in Dominica, it cannot be done.
We don't have that law. So you can apply for the person to apply on your behalf until such time as you can, that you can do a power of attorney to that extent, but you cannot take the power, apply and get letters of administration or probate, and then give a power of attorney for somebody else to act.
But there has been some discussion on that because some authorities actually say that because you are the executor and your power derives directly from the testator, who is the person who has died, then you have the authority to delegate your power. So it is only for executors. But where you apply for grant of letters of administration, because
yeah.
you're an administrator and it is the court who has appointed you, then you cannot delegate that authority without the permission of the court.
So by delegating so there's certain things you can delegate as person representative or executor.
So
You can delegate
administrator
administrative
from the court. The
Right.
court gives you the authority. Executor is the person who died, who
Yes.
gave you that authority before
So now,
he died.
if you're an executor, you can grant a power of attorney for the person to deal with the administration of the estate.
Right.
But if you are an administrator,
Yes. So that goes back to the gentleman who just called and asked the question. If his wife had done that, then is it possible that the husband could know?
In that case, which your caller mentioned, it's both she lost her mental capacity. I think
so
so.
she
It
cannot.
made
That
it,
would not, yes.
It made it impossible.
But doesn't losing your mental capacity, isn't that only for power of attorney? Does it also come into play if it's executor?
Oh yes, if you're an executor of lost your mental capacity, you cannot act. You have to have the ability to administer the estate.
Right.
Okay.
So once you've lost the mental capacity, you
Because
can.
you have to make decisions.
Yeah, you have to make decisions. In fact, that usually a beneficiary or somebody else would apply to replace the person who's lost their mental
Unless there was a
capacity.
co-executor or something. then-
Unless it's a co-executor who can continue to act.
Yes.
Yeah.
But
Wow.
yeah.
It's quite a bit. It's
Yes.
quite a bit.
And it's complex, as you can see.
It
Myself
is
and
complex.
Fanilia disagree on
Yes.
point. And
we always have that.
With regard to powers of attorney, it is tricky because the law
It's
it's not uncertain. It really depends
It's
on the law
fluid
that
then.
is passed in the particular country a lot of the times. So,
And how it
so
is drafted.
England might have a particular piece of legislation, and we might say, okay, we follow England most of the time, but in this case, we don't, and therefore we can't follow that. But it is a complex area, and in fact, I remember we were talking sometime earlier about we probably could have for lawyers a continuing legal education session on just powers of attorney.
Sure.
And it is highly dependent on how the power of attorney is drafted. So sometimes you get people saying, oh, but somebody else came with a power of attorney and they were able to do this, and then I come with a power of attorney, I'm not able. It depends on how it is drafted, the words that you use in the power of attorney, which is why we do not recommend a do-it-yourself approach, and we recommend that you go to an attorney when you have to prepare a power of attorney.
And the other thing, as she said that, whether someone will act on a power of attorney or not has a lot to do with the person being comfortable that the power is being granted.
You're right.
So you may do a power of attorney for something and take it to one bank and the bank accept it, take it to another bank and they don't accept it.
Yeah, because they won't
don't
have
feel
their
they're
peculiarity.
protected.
Yes.
Right.
Yes.
Because that's what the power of attorney is for.
Yes.
It is for the attorney to be protected, but it is also to protect the person who's going to be acting.
Yes, absolutely. Wow, ladies. So I'm going to give you a moment to think about our closing remarks. We just want to again thank those of you who are so engaged online. Peter Dover is saying that he's proud of the panel. So ladies, take a bow. Proud of the panel. Questions well answered. Margaret is saying it's a very good program for us living abroad. How do some of us know? Not sure exactly what she means, but it's great for persons living abroad who may want to do business in Dominica. Someone said to me, next time we need sign language.
Yeah,
Of course, that's interesting to note. Hopefully, that is something that we can do in the future.
Yeah,
Yes.
It is important for persons who live abroad because
Absolutely.
a lot of the time they will go to an attorney abroad and the attorney will give them a power of attorney that is applicable wherever they are.
Right, but
And it
not
may
for
be applicable
Dominica.
here.
Yes. So they have to find out if it's going to be, used in Dominica.
Should be
know,
drafted by
should be
somebody
drafted by
who is familiar with
Right.
our
Yes.
regulations and our
Yes.
laws.
Yes, absolutely. So ladies, I'll start with you, Indira.
Okay, sure.
Or probably we could go back to Fanilia because you had already started talking about your two most important points.
Oh,
yes.
So one was the review. So, we generally advise people to review their power of attorney ever so often. And the second point that I think Joel wanted me to touch on was what exactly the banks look for when you come with power of attorneys. when you come with power of attorneys, banks generally look to see whether you have met all the formalities for the creation of the power of attorney, whether it's signed by the donor, whether the affidavit of due execution is attached, if it is a document that is coming from overseas, whether it is notarized and there is a notarial certificate, the registration as well, and they normally look through the document to ensure that it does not reference the legislation of another country, because if it does, then the bank cannot act on the power of attorney. So all of those things, and also in interpreting the power of attorney, I think that that is my Achilles heel when it comes to because everybody writes differently.
Right.
People use different phrases and terms, and sometimes we do not appreciate the meanings of certain things that we say or we put down on paper, how it is phrased. So it is very important that for the banks, that the power that the person is attempting to exercise, that the power of attorney actually gives it. So my recommendation is that if it is you're drafting a power of attorney, even if it's a general power of attorney, you still have to state exactly what it is, what powers that you want to grant to the person. So don't just phrase it broadly, because if the bank is unsure, they're not going to act on it.
Right. So
it means that you have to go back and do a new one. So to save yourself,
sign and receive.
So every power you want to grant, you specifically state it. You want the person to have access to more banking, you state it. You want the person to withdraw, you state it. You want the person to be able to deposit, you state
all
it.
of that.
Everything must be stated clearly.
Don't just say to
act on my behalf, right?
Or manage my financial affairs.
That is not going to allow the person to take a loan if that's what you want them to
So
do.
Jada, who is asking, so a power of attorney can be selective to whatever you want someone to do for you. That answers your question.
It's not can be, it is.
Yes,
That's what
it is.
and
Yes.
it has to be.
Has to be.
Nothing is going to be assumed. So you can't get close and assume. If it can state very specific things, and then say other such things, and it will then apply to things in that category.
Right.
But it will not go outside of that category and assume anything.
Right.
It won't work that way. It has to be very specific. A power of attorney is a very specific document appointing and giving authority to someone else. Very, very specific.
Can I take that as your final words, or do you have your own final words now?
That's fine. That's fine. That's very fine.
That's read up for you.
Okay,
Indira seconded that
I
motion.
seconded that motion. Yep.
Indira, yes.
So yeah.
Yes.
Oh,
Indira?
yeah.
Yes.
The power of attorney, I mean, we've said most of it. The power of attorney is a very useful tool.
Yeah.
Sometimes people don't even know about the power of attorney, but if I have a client who is overseas and I can see them struggling with making decisions about, boy, what am I going to do about this and that, I might suggest to them a power of attorney, right? So it's because it's a very useful tool. But like we said, it's useful, but there are legal repercussions, and so you take every safeguard. Every single person involved, donor, you have to consider as well what we said, what the banks require, because a lot of it, most of the time, is to do with financial matters. So you take all of that into consideration and ensure that the proper safeguards are in place. First thing, seek legal advice. Let an attorney do the power of attorney for you.
Right.
All right? Do not attempt to do powers of attorney for yourself. It is just not advisable. What happens? It always comes back around.
Yes,
you
it
end up in
bites you.
some legal right.
Yeah.
So do that first. The lawyer should be able to advise you properly. And I mean, like I said, it's useful. It can give people a lot of peace of mind. So it's just to ensure that we're within the legal requirements and that all safeguards are taken. People who are acting as power of attorney, please do not do anything that the person would not do, because you are actually acting on behalf of the person.
So don't go and marry.
Do not go to you can marry, but that'll be on you. Do not go outside of your powers, because the person can sue, so just
I want my final word to be this. Because I don't want to accept the last one anymore, because while Indira was
Dean came
speaking,
in, so
my mic
that's
was
our
speaking.
cue.
What I think is important, everybody who's interested in what we're talking about, who thinks maybe that they might want someone to take care of them if they lose their mental capacity,
yes,
do what you can to go to the representatives in Parliament or wherever, for them to look at these laws again.
Yes.
We really need to look
Yes.
at our Mental Health Act with the regulations, and we need to look at whether we want to do enduring powers of attorney or lasting powers of attorney, which are slightly different. We didn't get to touch on that.
Yeah.
But so that we can take care of the vulnerable
Yes.
a little better, because they're being taken advantage of because of these little loopholes and because of the lack of provisioning that we have.
Yeah.
And we can do it. There's legislation out there, there's regulations out there that we can follow,
Yes.
that we can use to guide us. It's not, every passing a legislation is difficult, but it's not impossible. It can be done. This is something that we deal with as attorneys all the time. And Fanilia at the bank can say, her stories, her horror stories of what happened.
Yeah.
So we need these laws to be looked at.
Yes.
And we need them to be improved. I think that's what I want my closing.
That's a very good closing.
Very good.
Very
Very
good.
good
Very
closing,
good.
Joanne. Yes.
Someone is asking, Cecilia, is there a fee for being a power of attorney? Or we spoke about the document
We spoke
and
about
all the
we
stamps
spoke
that
about the
needs to be
registration
bought.
fees and
Yes,
stuff.
You don't get
registration
paid
fee.
to be
But you don't
a
get paid.
No,
to
you don't get
do
paid.
that.
as the don-
If
as the
you
Yeah.
if you
You don't get paid and you
expend-
don't pay
If you
too.
expend money in doing the act, then it's reimbursed.
Reimbursed.
You can be reimbursed this money, but you don't get you. It's not a job.
It's not a job.
Yeah,
It's not a job.
Unless you negotiate. If the person agrees to pay you,
Then
then.
that's fine.
Yeah.
But as a matter of course, no.
Okay.
Because to the person
Yeah, so making me apt and
yes,
not paying.
exactly.
Yeah. So it's not like I don't think it's generally like a service people would provide per se, is it?
No, that's why it's meant to be somebody you trust.
You trust.
So
Right.
somebody
Yes.
there is a
Exactly.
relationship
Thank you.
with,
Right.
That is
who
it,
will be
exactly.
willing to undertake
Right.
this on your behalf.
Yes.
Mhm.
Is that your final words, Gina?
Maybe
So
two
you
brief
can go
points,
ahead.
for
Yes,
the
we didn't hear you
listeners.
much, so we could.
Understanding the power you intend to give,
Yes.
and ensure that it's clearly stated in the document.
Mhm.
And I think one of the other very important point would be, as we said before, and we can't say it enough, ensure that the person you're giving the power to is somebody that you trust. That will be acting in your best interest.
Yes.
And monitor them. Keep monitoring
Yes.
them.
That's
Yes.
basically.
You should.
Yes.
Most people
Absolutely.
don't.
Yeah, you have to
Because the whole
monitor
point
them.
is
Even
that
with
you have
someone
the
you
time.
trust, you never just, let it go and just,
It's
like
not
you
just
said,
somebody
keep
you trust,
monitoring.
but somebody who is trustworthy.
Trustworthy.
Because you can trust somebody who
And they're
is
not
a
Not trustworthy. Yes. So trust is a very, very important word. So two, very important things that I heard tonight. Trust in terms of power of attorney and really being specific. But I think trust is the big word here, because you're basically having someone else act as you
Yeah,
per se,
exactly. That's what it is.
so
And you're obligated, most powers of attorney will have a ratification clause where the person who's giving the power is obligated to ratify whatever the person has done.
Has done.
Once it's within, it's covered within the power of attorney.
yes.
So
So
it has to be-
there is protection there to a certain extent.
Well, for the person
For
who's
the donee.
acting.
For person who is
For the
acting.
donee, yes.
All right, ladies, I want to thank you so much, Fanilia Frederick, for the person who's asking who are these wonderful attorneys, these ladies, Fanilia Frederick, Joel Harris, and Indira Seja. Also with us, Jenna Abraham Thomas. Thank you so much to all those of you who joined us on Facebook, who interacted with us tonight, those of you who called and asked questions. We are here every other Monday. Sometimes, for some reason or another, we have to shift our program, but every 2 Mondays, we are here on DBS Radio with interesting topics as it pertains to the law and you in Dominica. So, the Dominica Bar Association is really making an effort to educate people, to make sure that you have the necessary information that you need. We always say it's not a consultation, not a personal consultation per se, but we encourage you when you have these personal matters to visit a lawyer. But at least, you get to learn, certain things here. So be sure to tune in every other Monday. And thank you so much, ladies. I learned a lot, and I'm sure our audience learned a lot as well.
Thank you, Timothy.
You're most welcome. We want to thank S-Smart for sponsoring tonight's program. So until 2 Mondays from now, not sure what the topic will be, but look out for it. Maybe we might come back and finish talk about this. You never know.
Yes, Fanilia has said she wants to come back. So.
Well, there you go. There you go. So So until such time, we want to say good evening and thank you so much.
Thank you.
Thank you, everyone.
Thank you.
Good night to everyone.
Good night.
For all your shopping needs at the best prices in Dominica, shop at S-Mart. Shop smart at S-Mart.
Shop smart at S-Mart.
Can you get me some Lotto?
Oh, my favorite
Shop
snacks.
smart at S-Mart.
I get a top up, flow, and digital.
Shop smart at S-Mart.
Sunday to Sunday.
Open on holidays.
Shop smart at S-Mart.
So much fresh fruit and produce.
Good quality service. Unlimited parking. All the best products at S-Mart. You get the best prices.
Shop smart at S-Mart.
Be safe and be prepared. Be a smart shopper this hurricane season. Shop at S-Mart and get the essential hurricane supplies in one stop. A smart shopper will ensure his hurricane supplies includes Creek's Vital Supplies, Spotless Bleach for purifying water and treating of mosquitoes, Oasis bottled water, lanterns, flashlights, and long-lasting Duracell batteries to power your equipment and radio. A variety of canned and preserved foods and grocery items, personal and healthcare items. The hurricane season is worry enough. Worry less. Shop smart at S-Mart and ensure that you have all the supplies to weather the storm before, during, and after.
Hey, Mikey, this one's for you, man. Rest well, my brother.
He was a father, songwriter, and teacher, a champion of law and order. He was a brother to the least of our brothers. Remember him. We must remember him. We will remember him. Oh, we will remember him. Even when he's gone. Oh, yeah, yeah.
He left his mark as a radio announcer and at the People's Action Theatre. When he gave his full measure. Remember him. We must remember him. We will remember